Welcome to the webinar. Today we're at Legal Aid New South Wales Central Sydney office, and before we start we would like to acknowledge and pay our respects to the Gadigal people of the Eora Nation, who are the traditional owners and custodians of the land we're broadcasting from. My name is Jessica Sullivan and I'm from the CLE branch at Legal Aid New South Wales, and with me today is my colleague Matthew Butt, who is a senior solicitor in the family litigation team. Hi Matthew.
Good morning.
Thanks for joining us. So today's webinar is part of our Law for Community Workers program and will be about the Working with Children checks. We're talking about this topic for a combination of reasons. Firstly, because we were contacted by a number of community workers who had spoken to or dealt with people in their work who had lost their jobs or were struggling to gain employment because they hadn't been able to get a Working with Children check. It was also reported to us that there was a misconception in the community that if you had a criminal record or a history with police, that you wouldn't be able to get a Working with Children check and you wouldn't be able to work with or volunteer with children. So in this webinar today, we're going to be discussing what a Working with Children check is, who needs one, how to get one, what to do if you get refused a Working with Children check. But please be aware that we are only talking about working with children checks within New South Wales. The other laws in other states and territories are different. Okay, so the overview of today's webinar, as I just mentioned, what is a working with children check, who needs one, the application process, what to do if you're not happy, and then we'll have time for questions at the end. So, firstly, Matt, can you explain for us what is a Working with Children check?
So, thank you. So a Working with Children check is a form of screening, and the purpose of the screening is to identify people who may pose a risk to the safety of children. It is administered by the Office of the Children's Guardian, who receive and determine applications for Working with Children check clearances, and they also do some community education around child safety. It applies to adults who will be in child-related work. Child-related work includes both paid work and voluntary work that directly involves working with children. There are also some particular roles that do involve children, but are specifically identified as ones where to hold that position, you must have a Working with Children check. So a common example is to be a foster carer, or as it's called legally, an authorised carer, and any other adult in that household as well.
Okay, great. And are there some situations where people don't actually need a Working with Children check or are exempt from needing one?
So generally, of course, if you're not in a child-related job, you don't need to hold a Working with Children check. Although it is really important to know, in terms of thinking about the impact on people that you come across, that over the time this scheme has been in place in New South Wales, more and more organisations, employers, community groups, sporting associations have required their employees and volunteers to hold a Working with Children check, even if perhaps not strictly required by the law. So, and there's nothing wrong with that. It's just a fact of the way the system's operating at the moment. There are also a range of exemptions in the law. Probably the most common one that comes up is in day-to-day is for parents. So generally speaking, parents are not required legally to have a Working with Children check to, do all the things that parents do at their kids' school, like volunteer with teams that their children are in, or be on the cake stall and so forth. So, but again, it really depends on the school.
And is that even if, say, a parent was volunteering to help with a reading group or something in their child's class, in that reading group there's other children from the class, they still don't need a Working with Children check? So
legally they don't generally, because they're involved in an activity involving their own child as well. But of course some schools might require it. Okay. And there are also some school situations where the law does require even parents to hold working with children checks. So last year, the law was amended so that parents were required to hold a working with children check if they go on an overnight school camp.
Right, okay. So, right. So moving on, how do people apply for a working with children check?
So you make an application to the Office of the Children's Guardian. You need to provide standard identification documents as part of that application. There's an online application, I think, through Service New South Wales, which is probably the easiest way to do it for people with their identity documents, although of course that can be hard for some people.
Yeah, if you don't have the internet, there's also the option to go into an RMS or a Service New South Wales centre with your documents. And it's also probably just worth mentioning as well that the cost, it is free if you are a volunteer, an authorised carer or an adult living in an authorised carer's home. Is that correct?
Yeah, it's essentially free in circumstances where there's a requirement and it's not employment related. So someone's doing it and has to have one, and they're doing something that's of social benefit, like being an authorised carer.
Okay. And then for everybody else, the fee is $80, is that correct?
I think that's right. Yeah, $80.
Okay, great. And it is something that you don't just get one and then that's it for the rest of it. You do need to get them renewed.
Yeah, so it was an important change some years ago that you just need one generally. It's not related to a particular role. So once you have a working with children check, you can present, it has a number attached to it, and you can give that number to any employer or voluntary organisation, and they are obliged to then run a check on that by sending that information to the Children's Guardian to check that you hold a valid clearance. Once you have a clearance, a working with children check, it remains valid for 5 years, after which time it has to be renewed.
Okay.
So that there's just been a big round of renewals because the first 5 years of the scheme have just passed.
Right.
That's subject to this. One of the important and good features of the scheme is that it's a continuous monitoring scheme. So you have a clearance for 5 years, but if in that time the Children's Guardian is informed that you have been found guilty of an offence, say an offence involving children, or another offence that's a trigger offence for the Children's Guardian, or there's, say, been a finding by a government organisation that you have committed a serious physical assault or have offended sexually against a child, that will certain organisations are required to report that information to the Children's Guardian, who will then reassess and cancel the clearance.
Okay. So that leads us quite well into the next kind of topic, which is, because this is for community workers, a lot of clients may have a criminal record. So before we talk about that though, can I get you to explain what is the difference between a working with children check and a police check, or what some people might call a criminal record check? Yeah,
so a standard police check will identify convictions and the sentence that was imposed for those convictions, and it will also provide certain other information such as bail history and AVOs. The working with children check is a more substantial screening process than that. It includes a police check, but it will also identify other information that may show that you're a risk to the safety of children. So, for example, if there's been a finding by the Department of Family and Community Services that you've caused harm to a child, that information will be available to the Children's Guardian, and it will be considered as part of determining whether you do pose a risk.
Okay. And so on that, what happens if you do have a criminal record and you apply for a working with children check?
So the answer is it depends. There are certain offences which are very serious offences involving children that are called disqualifying offences. So if you have been convicted of an offence like that, your application for a working with children check must be refused at first instance by the children's guardian. And you can only obtain a working with children check if you appeal to the New South Wales Civil and Administrative Tribunal. So the children's guardian simply will not consider, it is not permitted and will not consider your application if that's your criminal record. Now, there's also a smaller subset of those crimes where you're not in fact even allowed to appeal. You simply cannot have a working with children check.
Right.
Now, then there are a range of offences which do not prevent you holding a working with children check, but which require the children's guardian to conduct a full risk assessment of you and whether you pose a risk to the safety of children. So those are obviously still very serious offences involving children, but are regarded as by the law as less serious, or at least ones where it's appropriate to inquire whether the offence demonstrates that you're a risk to the safety of children.
Okay.
So, for example, and people have different views about this, but for example, some carnal knowledge offences relating to young people are not disqualifying, but they do require that there be a risk assessment. Now, so they're those two categories. Lastly, of course, there are a range of other criminal offences which may cause the children's guardian to have a concern and may cause them to risk assess your application in a more thorough way anyway. They can always risk assess any application, but it's discretionary. If it's just a range of standard offences that don't particularly involve children, they may choose to conduct a risk assessment. For example, if you've got a substantial history of driving offences that indicate a problem with alcohol, the children's guardian isn't required to risk assess your application, but may choose to do so. Okay. Of course, the vast majority of applications go through in 2 to 10 days because people don't have a relevant criminal or disciplinary record. What we're talking about is a much smaller subset of applications where there are more serious offences where there are real issues, which doesn't mean, of course, that the person can't demonstrate that they're no longer a risk to children. For example, if there's been a turnaround in their life and a passage of time without an offence, but their application will be looked at much more closely, and those processes can actually take quite some time for the children's guardian to give you a decision as well, which can impact people in its own way.
Okay, and we will talk more about the risk assessment a little bit later on in this webinar. So the next question I have for you is, when can I start to work or care for children? So after I apply, once I've applied, does that mean I can start working or caring for children?
Yeah, so the requirement of the law is that you need to have an application lodged that hasn't, and so if an application's been lodged but hasn't been determined, you meet the requirements of the Act. But of course, in practice, a lot of employers and voluntary organisations will want to see that you can actually hold the working with children check before letting you start working or volunteer with children, because of course, if something happens and a child is harmed, a question will be raised about their conduct. So in practice, you'll find many people may be unable to take up a position without one.
Okay.
Again, for most people, that's not a significant problem because most applications are processed actually very quickly. But it can be a problem for someone with a concerning criminal history because the children's guardian can take some months to determine those applications.
Mm-hmm. We're going to move to, thank you, Matt. We're going to move to a case study now. So if you've been listening, this should be pretty easy for you. So this is Stephen. Stephen wants to volunteer at his son's school to help with the football team. He has criminal convictions for drink driving and assault police that he got in his 20s. He's had no other convictions since then. He previously had issues with alcohol but has not been drinking for 5 years. He's now 35 years old. So the question is, does Stephen need a working with children check to volunteer at his son's school? So there's a poll that's just been opened up on your screen at the moment. So the possible answers are: if his son is on the team, he may not need one. Yes, he's working with children, he will definitely need one. And everyone should have a working with children check, so yes. So I'll just give you another moment to answer that one. Okay, great. So we've got 71% said yes, he's working with children, he will need one. And 30% have said if his son is on the team, he may not need one. So Matt, do you want to talk us through what the correct answer for that one is?
So in fact, generally speaking, he is not legally required to have a working with children check, because what we're talking about here is a situation where a parent is volunteering with a team or activity in which their own child usually participates. Again, as I said, there are some exceptions, like if there was, say, an overnight aspect to a camp or something, and there are also particular exceptions where there are children with disabilities. But generally speaking, he's not legally required to have one. The school, however, may want all parents to have one. That would depend on the school, but the law doesn't require him to have one. Whether he would successfully get one, if required, really depends. I mean, I think it's important when you're talking to people about these situations to talk about a couple of things. One is a bit of realism about what their background is and why they want the working with children check. The other is that if people really need it and it's important to them, and there appears to be some good grounds for suggesting that, for example, that these are issues in the past for them, then they should be encouraged to get legal advice and consider their legal options if an application is refused. And I think the last important thing to talk about is a certain level of transparency about your past and your past history is required to go through this process. And that's something that people need to understand, because these are sometimes things that they won't have disclosed to many other people, and they need to weigh up all of those things when they're making their decisions. But you know, this is the kind of case that probably all of us have come across. You know, it's a certain trajectory for men in particular. Most men with a history of younger offending age out, as they say, as time goes on, and family and children are an important factor for a lot of them. So, and it looks on the facts like he's had a period that is offence-free. So this is the kind of situation where if he needed it and it was refused and it was important to him, I would consider getting some more information from him and consider that he may well have a good chance at appealing the children's guardian's decision to the Civil and Administrative Tribunal.
Great. Okay, great. Thanks, Matt. So moving on again now to our next question, which we've kind of covered, but we'll go through again. So what happens after somebody applies for a working with children check?
So on receiving your application, the children's guardian will do a criminal check, and they'll also look at whether there are sort of relevant findings. For example, as I mentioned before, findings by community services about serious physical harm or sexual offending against a child. If that process comes through without anything of concern, the clearance will usually be granted quite quickly. If, however, that process throws up issues of concern, then the children's guardian may choose to do a more thorough review, which is called a risk assessment, or it may be required to do that more thorough review and risk assessment, or it may be required by the law to simply refuse your application. There are only two outcomes. So a clearance is either granted generally, so that you are permitted to work with children, or it is refused. There's no middle ground. So sometimes people will say, but all I want it for is to do something at my kid's school, and the school needs me to have it, or wants me to have it. I don't want to work with children. I don't want to be a foster carer. That's all relevant to understanding their motivations, but from the children's guardian's perspective and the law's perspective, they have to decide whether the person is a risk to children generally, were they to do anything that involves children. So they can either grant or refuse, but they're the only two options. They can't say grant it and say, we'll grant it to you, but only if you volunteer at your kid's school. You've got to promise not to go anywhere else. That issue has actually been tested out a bit, and the law doesn't allow for it.
Okay. And that leads us on to exactly what my next question was, which is, what is a risk assessment? So you have mentioned it a few times already, but the process, I guess, what does it really involve?
So risk assessment is just a name for a process of considering all the information that you know about a person and their background, circumstances and history, and thinking about whether they pose a risk to the safety of children now. So, it might involve looking at, if you've got convictions or offences, it might involve looking at how serious were those offences, or what were the circumstances of those offences. For example, was alcohol involved, and is there evidence now that alcohol is no longer a problem for this person? It might look at the age of the victim of the offence. Was it a very young child, or was it a young teenager? And it might look at any information the person provides about how their circumstances have changed. In many of these cases, there's no sensible real dispute that the offence history shows that there could well be a risk. And the real issue is, have things changed for this person so that they can show that they're not a risk?
Okay, and something that would be looked at during this process if the person had, say, had an AVO taken out against them at one point or another?
Yeah, so yes, maybe, it depends. So the level of thoroughness of the risk assessment by the children's guardian depends probably on the circumstances. So as I said, for example, some convictions effectively lead to an automatic refusal, and the children's guardian won't have actually necessarily gone and looked at anything else because they've looked at what's sufficient for them to resolve the issue. And it's only at the Civil and Administrative Tribunal that a much more thorough risk assessment will be undertaken. But in other cases, if the children's guardian has wider information about the person's history and background, they are not limited to considering simply just convictions and disciplinary findings. In fact, it is open to the children's guardian or the tribunal, if you're appealing, to consider even criminal matters where you were found not guilty, because a not guilty finding by a court just reflects the very high standard of proof that's required for a criminal conviction. A much lower standard of proof may be sufficient to raise a real concern about whether the person should be involved with children. Similarly, apprehended violence orders may well be taken account of as part of a general assessment of a person's circumstances and whether they're a risk, even though they themselves are not convictions, because an AVO is not a criminal conviction. and of themselves don't require that that a working with children check be risk assessed or refused.
Okay. And so what happens if you don't get a working with children check?
So
So say if you're a community worker and someone comes to you and says, I want to get this job helping young people, but I was rejected. I didn't get a working with children check. What does it mean? What can I do? So what advice, I think, could you give to community workers to say to their clients at that point?
So the first thing always for all of us in our helping roles is to help people understand their options, of course. And so the first thing that the person needs to know is that generally, with very limited exceptions, if you've been refused a clearance, you cannot reapply for 5 years. And in that 5-year period, you are barred from working with children, and it's an offence for you or an employer to not abide by that. And as I said, it can have even wider implications because many community organisations, for example, will also require it. I've had cases where a volunteer at a charity is sort of helping out in the back office and not at all involved with children, but for obvious reasons, charitable organisations and other community organisations are extremely cautious and will often require everyone to hold a working with children check. So that's the first thing. If refused, you cannot work with children or volunteer, and you cannot reapply for 5 years, except for, without going into the detail, very limited exceptions to that. The next thing they need to know is that in most cases, other than for some very serious offences, or when someone's actually currently before the court for a serious offence, they have a right of appeal. And that is a right of full appeal. In other words, they can go to the Civil and Administrative Tribunal, which is an impartial tribunal, and have the whole case looked at again, including providing much more information from themselves than they may have originally provided, although equally the children's guardian may also go and do some further investigation of your circumstances. But that's their main option, is an appeal. The last thing is time limits, as always, 28 days to lodge that appeal. So they don't have long to potentially seek some advice or think about that option before that time limit expires. But that time limit can be extended in certain cases, but it's important that people know about that time limit.
Okay, so it's best to act fast if you want to appeal. So moving on to, if you did appeal or challenge this decision, what are your options?
Well, your main option is to go to the New South Wales Civil and Administrative Tribunal, or NCAT. If you appeal a working with children check decision, and most decisions can be appealed, it will hold a hearing where you can present evidence and the children's guardian can present evidence, and have a tribunal take a fresh look at all the material to determine whether you pose a risk to the safety of children. There's an application fee for the tribunal, generally about $100, but much less if you're entitled to a concession, for example, if you're on benefits. But after that filing fee, that process is free. And even if you're unsuccessful, you do not have to pay the lawyer's fees of the children's guardian. So it can be a reasonable option for even low-income people who feel that the decision against them is unfair. It's also generally anonymous. Most of these hearings and decisions cannot be reported. Now, that's not for the benefit of the applicant, it's for the benefit of the children who might otherwise be identified. But it does have that benefit for people, that they also will generally not result in a public decision naming them and connecting them to you know, an offence or something that's in their past and that they may not have told people about. Although, of course, decisions are published and people who know all the facts may well be able to identify them. So that's your main option, and that's the main issues for people, the cost, and I think a lot of people think hard about privacy and their history in these kinds of cases actually as well.
And the two words that we've chosen to pop up on your screen at the moment, they just relate to the children's guardian will send you a letter if you didn't get a working with children check. Is that correct?
Yeah, and they have to provide you with fairly detailed reasons.
Okay, great. And so if you are refused because of a risk assessment, then what you should apply for is a review. And if you were refused because of a disqualifying offence, what you need to ask for is an enabling order.
That's true, and there are technically different forms in NCAT, and it can be quite confusing, and the tribunal is not particularly clear about it either. In terms of helping people, really the main thing is to apply. The forms and the process have different names, but they're basically the same. And so really it's just about lodging that application as soon as possible, and ideally within 28 days, so that there's no issue about being out of time. If you get the form wrong, usually the tribunal and the children's guardian, that happens quite a lot, and they'll just proceed and work out what the proper course is, and you won't be in trouble for not filing the correct form.
Okay, so the best thing is just to file as quickly as possible, essentially.
Yeah, absolutely, because you also, and this is probably something they would need some legal advice about, this is a more difficult thing, it can have an immediate impact. So if you're a foster carer and for some reason your clearance is cancelled, or you were intending to become a foster carer and you applied and the children were placed with you, but then it's been refused, those children must be removed in 48 hours. Or the adult without the working with children check must leave the home, one or the other. So there are some situations where you can get what's called a stay from the tribunal to prevent any action like that, although that is quite difficult. But people need to move quickly, not just because of the time limit, but also because in some situations it can lead to removal of children or placement elsewhere. And I think in those kinds of cases, the best thing to do is to try and put them in touch with a lawyer. Working out how to handle those situations and what's appropriate can be quite tricky.
So if you are appealing, can you work or volunteer after you've appealed? So essentially the stay is exactly what you're talking about.
Yeah, so there is this thing called a stay, where a stay is the legal term for an order of the tribunal that keeps the status quo in place. So if the children's guardian cancels your working with children check and you successfully obtain a stay, then the law treats it as though you still had your working with children check. There's a separate application to NCAT, and there'll be a separate little hearing about it, particularly if the children's guardian doesn't agree. For obvious reasons, it can be difficult to successfully get a stay, because if there's a real concern that you're a risk to the safety of children, then leaving a stay in place for some months where that risk may eventuate is something that a tribunal is going to be very reluctant to do. So it's not impossible. It may be appropriate in some cases. It's a really important thing to consider, but probably the best thing you can do for someone with those kinds of questions is two things probably. One is to try and put them in touch with someone at Legal Aid to give them some advice about it. Probably the other thing is perhaps sort of a common sense kind of discussion with them about what their options are. Because if there's some really serious allegations going on, it might be that the best option is, for example, that they move out of the home and go and stay with family until it's sorted, rather than, for example, causing children to be disrupted and moved. But something that some legal advice would be good for.
And we've had a question from one of our participants today. How long does the appeals process take?
Yes, that's a good question because that's important for people to know. It's certainly not quick. So you generally won't get a sort of first meeting about the case at the tribunal for 4 to 6 weeks. And then how long it takes after that to get to a hearing depends mainly on how much time both the children's guardian and the applicant need to prepare their cases. So something I'll come to in a second is it's not uncommon for the applicant to want to get their own risk assessment to compete with the children's guardian's risk assessment. That can take months just to get an appointment. Then you've got to have a hearing. Then that would usually be half day to a 1-day hearing. And then you've got to wait often 2 to 3 months to get a decision from the tribunal. They often won't make a decision on the day. So all up, the tribunal generally aims to deal with these matters in, say, about 6 months. But, and many of them are done in about 6 months, but that's often because applicants are representing themselves and don't put on a lot of evidence, and the process goes fairly quickly. If a lawyer like myself gets involved, it can stretch out some months longer while we seek to prepare a case.
Okay, so moving back to the slide. So what, if any, categories you shouldn't get a working with children's check?
Yeah, so the Civil and Administrative Tribunal, NCAT, takes a fresh look at the evidence, including any new evidence that you want to provide, such as your own risk assessment, and makes up its own mind. However, it applies the same law, and that law fundamentally says that the only consideration is whether you pose a risk to the safety of children. So, for example, the law does not allow some weighing up of the risk you might pose versus the detriment to you of not having one. It's really all about the safety of children. That said, I think I'm right about these numbers, but don't hold me to it. I think in about maybe 1 in 4 appeals, NCAT takes a different view from the children's guardian and grants the clearance. So that's a reasonably considerable success rate, showing that it's important that people get advice and really consider an appeal if they think that the decision's unfair. However, it is the case that in the majority of cases, the tribunal does agree with the children's guardian. At that point, your legal options are limited. You are subject to the 5-year embargo on applying again for a clearance. You can appeal further to the New South Wales Supreme Court. However, that is a much more technical and narrow appeal. The Supreme Court will not hear the matter again. It will not look at new evidence. It will only check that the tribunal followed the law and applied a fair process. Now, there may be merit in that appeal, but that's really a technical question for a lawyer. And it's not like an appeal to the tribunal where, apart from the filing fee, the process is free. Generally speaking, if you appeal to the Supreme Court and you don't win, you'll have to pay the legal costs of the lawyers, the solicitors and barristers hired by the children's guardian, and you're looking at thousands of dollars there. So although there is a further appeal, it's much more technical, much less likely to succeed, and you should really only do it if a lawyer has considered it carefully and decided there's something in it.
So essentially the advice here is to speak to a lawyer.
Yeah, I mean, many people are represented by themselves in the Civil and Administrative Tribunal, and that may be, they may be fine perhaps just with a bit of advice. They may not need a lawyer, and the tribunal's used to managing that. And that's where most cases where probably a different decision could or should be made are going to be sorted out. You know, cases, for example, where your client clearly had a tough period, say in their teens and 20s, but 30 years later, and they're a grandmother or grandfather wanting to be involved in some activity or school, and there's considerable evidence that they no longer are a risk to anyone, the tribunals where those cases are going to be sorted out, not the Supreme Court.
Yeah, great. Okay, so before we finish up today, we're going to just look at one more case study quickly. So this is Brian, and Brian has previously been charged with assault of a minor, but was found not guilty of the offence at court. He also previously had one of his children removed by fax because of concerns about neglect. Now, Brian was refused a working with children check. So we're assuming in this case study that Brian obviously needs a working with children check for whatever work that he is doing. So we're going to ask one more poll question here. What are Brian's options, essentially? So Brian should accept that he can't get a working with children checks and just give up on that. Brian should get legal advice about his options, or should Brian challenge the decision? So I'll give you a few moments to answer that one, guys. Okay, so I'll just close that poll now and share those results with you. So we've got 83% of you think that Brian should get legal advice about his options, and 17% have said Brian should challenge the decision. So Matt, what do you think?
Well, I think he should get some legal advice and quite possibly challenge the decision. It really depends, but if obtaining the working with children check is important to him, perhaps for employment reasons, then he certainly should get some legal advice. And really looking at those facts, it depends. So those facts raise some serious concerns, of course. For example, leaving aside that he was found not guilty of the offence, community services remove children obviously when there are serious concerns that there are substantial risk of harm. So that fact of itself is a serious concern. But it all depends. This may be many years in the past. His children may have been restored to his care. He may have had some, real difficulties at the time with his mental health or substance abuse that are now under control. Equally, he may not have turned his life around. So really, it's about getting some legal advice and getting a full understanding of all the circumstances.
Okay, that sounds very fair. So that brings us to the end of this webinar, essentially. So if anyone has, well, firstly, thank you so much for everyone for joining us, and to Matt for your time and your expertise today.
Thanks, sir. Hopefully useful.
But we'll be online for a few moments now if anybody has any questions. We had one a bit earlier. I can get my question panel behaving. Where someone had asked, if you have been charged but not convicted of an offence, will this still show on the Working with Children check? If yes, are there any options to removing it?
Yeah, so that's a really good question. So charges without conviction can be considered and relied upon by the children's guardian or by the Civil and Administrative Tribunal. So we're operating in a different legal and practical space from the criminal law. So the criminal law has a very high standard, rightly, before someone can be convicted of an offence, particularly an offence that might lead to them going to prison. The only question we're asking ourselves in the Working with Children check area is, does someone pose a risk? And charges, even if they didn't lead to conviction, are relevant to considering that. So it's a good question. So there's no way around that fact. All right. If the children's guardian become aware of a charge, if it's a pending charge, like it's actually before the court for a serious offence, you may not be able to get a working with children check, and you actually can't appeal. You have to wait for the resolution of that case in some circumstances. Historic charges or historic allegations of any kind, for example, allegations of harming children while they were in your care that were made to community services but were never investigated. Equally, that history can come up in the working with children check process or on appeal, and there's nothing that you can do to simply reject that. Sometimes people will go to the tribunal and say, well, that was never proved, which is an important fact about it, and it says something about it, but that of itself won't necessarily deal with the issue properly. And then it really depends. You know, it may be that someone needs to go and get the court file and have a look at what happened. It may be that there'll need to be witnesses, perhaps because you continue to deny that those events ever happened. But it is open to find, legally, it's open to find that someone is a risk to children based on, for example, a history of charges and a history of allegations, none of them proven. And if we just put our common sense hat, there's a common sense to that, if we just put our common sense hat on, right? Sometimes it's impossible to work out what really happened, and courts or community services never get to the bottom of it, okay? And they have to apply a certain standard before they make a finding. But it is certainly the case that a history of charges or a history of allegations might, for example, show a pattern of behaviour that is of great concern. So it's just another long-winded way of me saying it all depends. It really does, and it certainly won't help the person to just go, they didn't prove it, so we don't have to worry about that. All that needs to be carefully considered when advising them, or if you're going to go to the tribunal and do your best to address the allegations. But it's really important to do both, because, you know, was it last year or the year before, not long ago, a foster carer who'd been the subject of a series of allegations really took their case all the way, and it was in fact found that none of those allegations had substance, and they should never have had the children removed or the working with children check cancelled. So those cases can raise some real concerns about fairness to the person who's the subject of the allegations, because it's very hard to refute allegations, but equally can also raise genuine concerns.
Okay, thank you, Matt, and thank you for the question. We haven't had any other questions come through, so if you do have any further questions, you can email those to the CLE branch here at Legal Aid, and that email address is just cle@legalaid.newsouthwales.gov.au. But we might sign off now, so thank you to everyone for joining us. You will receive an email to give us some feedback on this webinar, and we would really appreciate it if you could complete that survey so that we can continue to improve these webinars. In about an hour as well, you're going to receive an email with links to all of the resources that we've discussed today in the webinar. And there was a question about whether we can get a copy of this recording. So in about an hour or so, this will also be put up on our YouTube channel, on the Legal Aid New South Wales YouTube channel. So you will be able to watch it there and share it there with your colleagues if you would like to. So thank you very much, everybody, for joining us. And once again, thank you, Matt.
Thanks for having me.
Bye.